This video has been made to provide procedural guidance to lodging parties regarding the lodgement process for a grant application with the South Australian Probate Registry. This video is general in nature and does not provide specific guidance with respect to all types of applications. Court staff cannot provide legal advice. If you require legal advice concerning your application, you should speak to a lawyer who specialises in the area of wills and estates. This video is about the Courts Administration Authority's website and how to navigate to the CourtSA online portal to start your electronic application. On the screen now, we have the Courts Administration Authority homepage. This is where you should start when you want to navigate to the different areas relating to probate that I'm about to show you. Starting with, if you hover over probate and click on it, it'll take you to the probate homepage. To start with, what does the probate registry do? The probate registry has exclusive jurisdiction to issue grants within South Australia. It's a state-based jurisdiction, it's not a federal jurisdiction, so all states are different. If you need a grant over in New South Wales, for example, then their rules and processes are different and you have to contact the New South Wales Probate Registry. But in terms of the South Australian Probate Registry, we examine all of the grants for this state, i.e. we have exclusive jurisdiction. About 8,000 odd grant applications are examined per year. In addition, the registry also examines originating applications, caveats, renunciations and will deposits. A grant is a public document. You can search for historical grants from 1980 to present day via CourtSA. Pre-1980, it's either an email to inquiries@courts.sa.gov.au or a search on the Family Search website, depending on the date range you have. Alright, so acts, rules, practice notes, forms and fees. The probate rules are found in Chapter 25 of the Uniform Civil Rules 2020, and they set out the requirements for applications coming into the probate registry. Schedule 7 of the Uniform Civil Rules 2020 contain all of the standard template forms, and you should also be aware of the Succession Act 2023. Then, if you're looking for probate fees, you can click on the link that I'm hovering over and it'll take you to the fees page. The fees are set by the government and they change on the 1st of July every year. The fees for a grant is a tiered system and it's based on the gross value of the estate. If you're then looking for information about applying for a grant, whether that be for a grant of probate, a grant of administration or registration or reseal of a grant, this page here gives you quite a lot of information. Some of it will cross over with what I'm discussing in this video, but there's also more information on here for you to peruse. It is a lot of information on this page, so if it's easier for you to print it out and read it in hard copy, please do so, as I strongly encourage you to have a read of this information. As an applicant and or the lodging party, you'll need to determine whether you need to apply for a grant or not. The court does not determine this for you. Whether you require a grant or not is actually to do with the third party who's controlling the movement of the asset. So think about the Land Services Office, banks, nursing homes, share companies, etc. They generally will not release or transfer an asset they hold without the signature of the asset holder. If the asset holder dies, they obviously can't sign any documents. So the third party requests they be provided with a copy of the grant before they accept someone else's signature and transfer the asset, because the grant tells the asset holder who the legal personal representative is. The legal personal representative of the deceased can then sign the third party's documents for sale or transfer of the asset. Therefore, to obtain a grant, you need to come to the probate registry. However, you first must find out from the asset holders if they require a grant, because you may not have to go through this process if they don't. The next step is to determine which type of grant you should apply for as there are 5 types of grants: a grant of probate, a grant of administration with the will annexed, a grant of les administration, registration of an interstate grant, and reseal of an overseas grant. All 5 are particular types of grants with their own requirements. If you determine that you do need a grant and you know which type of grant, then you'll need to collect all the necessary documents to lodge your application. You'll need to register and log on to CourtSA, you do need access to a computer and have a bit of knowledge about technology to be able to do this. Then you complete the CourtSA application form, for which there is a separate video all about how to lodge a grant application on CourtSA. And once you have completed your online application form, you lodge the application and you pay the filing fee. Then, if there is an original will and any codicil, you must lodge the original will and any codicil with the court. The same goes if you have a duly authenticated copy of the court grant that you're seeking to register or reseal, so either the original grant or an exemplification, and you would be lodging that in hard copy with the court too. If you do not lodge the original will or the original grant, your application will not be examined. So skipping ahead to receiving your grant once it's been examined, you will receive email notification that the grant has been issued and you need to log back into CourtSA. Go to your case and the documents tab. Again, there's a separate video with more detail where I talk about the ins and outs of that side of the process. In some cases, you may need a form such as an affidavit to accompany your application. Those forms all sit here where my mouse is hovering, the probate forms, and there's 50 odd forms there also. On the website, you can download them as a Word version, and then you type the details in as relevant to your case. So this would include details of the deceased, details of the deponent, that's the person who's signing the affidavit, and then the story or chain of events you're trying to describe to the court. Please note the forms are templates, so you can delete text that is not relevant and add in paragraphs as required. Now, a common question that the registry receives is, can the registry settle an affidavit? No. Again, registry staff cannot provide legal advice, and settling an affidavit is going into the realms of giving legal advice. So if you need help with these affidavits, again, you need to seek the services of a solicitor who specialises in the area of wills and estates, because there is specific terminology for this area. So somebody who works day in, day out in this area would know their way around all of that. All right, so if you're looking to lodge your application, we'll go back to the home page and we'll click on the CourtSA online portal button in the right hand corner. So you need to register an account if you haven't done so already, and then we click login. We'll put in our email and our password, and then it will take you to the home page. So I'll stop the video here, and then there'll be a second video where I walk you through how to lodge a basic grant application on CourtSA.